as it pleases the court, my lord, I also drafted heads of arguments.
Yeah.
My lord, the copy that the court has was sent electronically. May I submit or hand over to the court a
I
signed
thought
copy?
I had them. Maybe yeah, okay, let's submit them. I thought I had them. Thanks.
It's a head of arguments in an application by the state to cross-examine Sfiso Zungu Gwabini on his previous statement. I'm drafting these heads, my lord, because
Yeah, I think I had them. It doesn't matter.
Advocate Nxumalo is not
On
here.
page, wait. Because then it means I read the wrong stuff. If you say electronically, what? Let's see, wait. Heads and on paragraph 13.1.
No, they end at page.
Paragraph 13.1.
Yes, they end
Yeah,
at
I've got
paragraph 13.1.
Signed electronically and unsigned. Yeah, fine, okay.
Yes.
Right.
So I was saying, my lord, that I've drafted heads of argument
Yeah.
in an application by the state to cross-examine Sfiso Zungu Gwabini on his previous statement. I've drafted these heads, my lord, on the understanding that my colleague Advocate Nxumalo is not here as well.
Yeah, fine. So they
in the
cover.
heads I've also included
They cover both.
accused number 5.
Yeah,
they cover
fine.
both. At 1, introduction. The state, in its heads of argument, brought an application to cross-examine a defense witness, Sfiso Zungu Gwabini, on his previous statement made in terms of the provisions of Section 224 of the Criminal Procedure Act, 51 of 1977, the Act. 1.2. Gwabini has been called as a defense witness on behalf of Muzika Ukulelwa Stemba Spear, accused number 1. The defense led Mr. Gwabini on the events of the 26th of October 2014 and the controverted the version of Constable Zungu at all material times and in all material respects. Therefore, since Constable Zungu testified that he was with all the accused at Masutini Hostel in questioning of Gwabini about what Constable Senzo Zungu was not limited to accused number 1's defense counsel alone. 1.3. During cross-examination by the state to Gwabini, the defense counsel for accused number 1 objected to the cross-examination of Gwabini on the contents of the statement that he made in terms of the provisions of Section 204 of the Act, on the basis that the state could not commence with cross-examination of Gwabini on the contents of the alleged statement until it has laid a foundation. My lord, I must firstly indicate that it is not a statement but an alleged statement in terms of the provisions, just to make it clear that there is no statement that the defense is saying Gwabini made, but you are making a reference to the alleged statement in terms of Section 2
Who alleges that?
of the state.
The state alleges that?
Yes.
Okay.
Yes.
Alleged statement of the state.
Yes, alleged statement
Of the state.
of the state in
Right,
terms
fine.
of Section 204 of the Criminal
Right.
Procedure Act 51 of 1977. 1.4. The state made several attempts to refer to its contents and the dates that the statement was made, as well as the address which is provided in the said statement. The defense counsel for accused number 1 objected to such a procedure. The court, in not less than 3 times, directed the state to prove the statement before it commences with cross-examination on the contents of the statement. In turn, the state made an application to file heads of arguments in order to ventilate the issues. My lord, I know that this application does not border on the evidence of Constable Zungu, but in my heads of arguments, I've also referred briefly to the evidence of Constable Zungu at paragraph 2 of my heads of arguments. The evidence of Constable Zungu, 2.1. The evidence of Constable Sikumbuzo Senzo Zungu was challenged by all defense counsel under cross-examination to this witness, that is Constable Senzo Zungu. The state had indicated during the evidence of Constable Zungu that it was going to call Gwabini, as Constable Zungu referred to him, that is Gwabini, in the evidence, in his evidence in chief. The state closed its case without calling Gwabini as a witness. What we learned, or what came out of this, of his evidence, was that he was a single witness for the state. 3, I discussed corroboration of witness or witnesses. My Lord, I refer at 3.1 to the case of State versus Gently, 2005, Volume 1, SACR 428, 430, where Clute in dealing with the approach to be followed by the court when it is faced with a situation where a court will caution itself in analyzing the evidence of the single witness. His sentiments find support in the case of State versus Hearsay, 2004, Volume 4, SACR 38 SCA at paragraph 12. It is clear, my Lord, from these authorities that if corroboration was required, it had for so-called cautionary role, it had to be corroboration implicating the accused and not merely corroboration in the material respect or respects. At 3.3, the evidence of Constable Zungu was not corroborated in all material respect. Gwabini was not called by the state to corroborate the version of Constable Zungu in relation to his evidence about the events of the 26th of October 2014. Paragraph 4, the cross-examination of Brigadier Geninda. 4.1, Gwabini was initially on the list of witnesses and he was not called. It came out at the commencement of cross-examination to Gwabini by the state that he had made a statement under the provisions of Section 204 of the Act. 4.2, the state did not call him to invoke the provisions of Section 204 and declare him a hostile witness if he deviates from the alleged statement in terms of the provisions of Section 190 of the Act. 4.3, Brigadier Geninda testified that the reason why Gwabini was not called by the state was that he feared for his life. In his evidence in chief, this assertion was refuted by Gwabini, who testified that he had in fact met the prosecution team led by Advocate Baloyi and the investigation team led by Brigadier Geninda. On the last occasion, he was turned away by Sergeant Mahola in the doorstep of this court. I submit that this is not the conduct of a person who feared for his own life, but a person who had a story to tell about what he knew. 4.4, the defense could not have challenged the evidence of Constable Zungu about what Gwabini testified about, since the defense was not privy to what Gwabini's turn-off events or knowledge of the events, as he was at the time that Constable Zungu testified as state witness. It was until the state closed its case that the state indicated that it will not be calling him anymore. 4.5, the other challenge, my Lord, that must surmount the threshold issue is whether was Gwabini a detained, arrested, or accused person, and if not, what rights of his were violated. The issue arises because Section 35(1) to subsection 1 to subsection 3 of the Constitution confer rights upon everyone who is arrested, subsection 1, everyone who is detained, subsection 2, and everyone and every accused person, subsection 3. 4.6, the evidence of Brigadier Geninda does not show that Gwabini was at some point arrested, detained, or having committed the murder of the deceased, Mr. Senzo Meyiwa.
How was the statement obtained, if at all?
We don't
if
know.
at all.
According to the version of the state, we don't know how
Okay,
it was
fine.
obtained. We don't know at all. Brigadier Geninda does not detail the status, my Lord, of Gwabini at the time of the alleged statement in terms of the provisions of Section 204.
Did he have an opportunity to do so?
And yes, when he was being led by the prosecution in his evidence in chief.
To give evidence about Mr. Gwabini Sfiso?
Yes.
I see. Okay.
Moreover, At no point, as it is evidenced, my lord, by the facts, was he was detained or arrested. The court became to know about his arrest for the first time when he, that is Gwabini, testified on the 24th of November, 2025. 4.7. The sequence of events as demonstrated by the straight to the evidence of Brigadier Gininda demonstrate that Gwabini was never an arrested and detained, or a suspect for that matter, for having committed the offense in question. The common law rule that exclude illegally obtained evidence continue to have application in circumstances where Section 35 of the Constitution is not of application because the right infringed is not a right in the Bill of Rights. Paragraph 5. The purpose of consultation by the prosecutor with witness or witnesses. 5.1. The purpose of consultation by the prosecution with state witnesses is to prepare the case for trial, ensure that all relevant facts are presented accurately, and uphold the integrity of the criminal justice system or process. 5.2. During consultation, the prosecutor can address any concern with the witness that he has about intimidation or threats, and ensure that appropriate measures are taken by referring the witness to the Witness Protection Program as it is allowed by law. It is clear, my lord, that no attempts were made as Brigadier Gininda did not testify about such means in his evidence in chief. So the fact that the state is saying that he feared for his life, that alone does not take or hold water in any way. At paragraph 6, I discussed the evidence of Gwabini about his arrest. The 6.1, the evidence of Gwabini is not on record. There is no need to repeat it. And it is not a subject of this application by the state, as in the sense that the court has indicated to Advocate Baloyi that he had to prove the alleged statement made by Gwabini. 6.2, it was the procedure that the defense supported. Instead, the state submitted that it wanted to draft heads of arguments to ventilate the issues, which issues would have been properly ventilated in cross-examination of Gwabini. 6.3, it is submitted that such a procedure is unheard of in our jurisprudence, and in application of the law, as the state has a right to cross-examine, and this right is not made out of application to the court, as it is allowed in our system or jurisprudence. 7, can a prosecutor cross-examine a defense witness about the previous statement when there were state witnesses? 7.1, the answer to this question is in the affirmative. The prosecution can cross-examine a defense witness about the previous inconsistent statement made when there were state witness, but they must first lay a proper foundation by having the witness own a statement. This means that the witness must first confirm that they did, in fact, make a statement to the police. Once this is established, the prosecution can then proceed with cross-examination or cross-examining the witness on any inconsistencies between earlier statement and their current testimony to challenge their cross-examination. Once this has been done, in the circumstances where a witness, my lord, disavowed having made a statement, that is the end of the story, and nothing can be done any further. The purpose of cross-examination. The purpose of cross-examination may be to test the credibility of a witness and to test the credibility of certain evidence, to elicit evidence that is favorable to your case. A litigant in both civil and criminal cases or proceedings has a right to cross-examine any witness called by other side who has been duly sworn. We find this, my lord, in the case of the South African Football Rugby Union and others, 2001, SA1. It's a Constitutional Court decision at paragraph 61. It was said in the passage endorsed and applied in State versus ISOP 2014, Volume 2, SACR 495. It's a KZN decision at paragraph 32. It is essential as a general rule when it is intended that the witness is not speaking the truth on a particular point, to direct the witness's attention to the fact by questions put in cross-examination, showing that the imputation is intended to be made and to afford the witness an opportunity while still in the witness box of giving an explanation open to the witness and of defending his or her character. Therefore, it follows that cross-examination is the right, not a subject of any application, as it has been done in this application by either the state or a defense in arriving at the truth. The provisions of Section 204, my Lord, are succinct. Section 204, subsection 1 of the Act provides that whenever the prosecutor, and I must repeat this, my Lord, whenever the prosecutor, not the defense, at criminal proceedings inform the court that any person called as a witness on behalf of the prosecution will be required by the prosecution to answer any questions which may incriminate such witness with regards to the offense specified by the prosecutor. So it is the duty of the prosecutor to inform the court when calling that witness, for the court to explain the provisions of Section 204, subsection 1, A to from Roman figure 1 to 4 of that section, that the court is satisfied that such witness or otherwise is otherwise a competent witness for the prosecution shall inform such witness that he is obliged to give evidence at proceedings in question. That question may be put to him which may incriminate him with regards to the offense specified by the prosecutor. That will be obliged to answer such questions. That if he answers frankly and honestly all questions put to him, he shall be discharged from prosecution. This was not done by the prosecutor. The state elected not to call Gwabini, having consulted with Gwabini on 3 occasions. And if Gwabini was indeed a 204 witness, and if he recant on his earlier statement, the state did not use the 2 mechanisms, that is Section 204 and Section 120 of the CPA, to discredit him. It is clear, my Lord, that Section 204 witness in terms of the Act must be called by the prosecution, and the state cannot invoke the provision of Section 204 during cross-examination to the witness, as such witness was a state witness and later called by the defense. Section 204 is designed to protect accomplices who testify for the prosecution against their co-offenders. The practice of allowing such persons to send state witnesses, however, should only be followed with great caution. My Lord, in this respect, I submit that there is no evidence to suggest that Gwabini was an accomplice to the murder of the deceased, Mr. Senzo Meyiwa, for him then to be turned the Section 204 witness, and thereafter makes a statement or the alleged statement in terms of those provisions. The effect of the section is that persons charged criminally with the accused are compellable witnesses, and such witnesses are deprived of the privilege set out in Section 203 of the Act, that is the Criminal Procedure Act. In Mohammed versus Attorney General of Natal and others, 1998, Volume 1, SACR 73, it's a Natal decision at 79, page 80, C to E, per Hunt J, for the discussion of the intention behind Section 204 and its place in our system of criminal procedure, said the following, and I quote, "The intention behind Section 204 is plain. There are many cases in which offenses are perpetrated by 2 or more offenders without there being any eyewitness. In these cases, there is often no circumstantial evidence on which a sufficiently certain conclusion as to the offender's guilt can be reached. The section enables the state to use one of the perpetrators as a witness to procure the conviction of the other on the principle akin to that of a bird on the hand being worth two in the bush. Without any further discussion, my Lord, on the provisions of Section 204, the court barred the state from invoking the provisions of Section 204 as Gwabini was no longer a witness for the prosecution. I now in turn respond to the state's heads of argument at paragraph 10, 10.1. Paragraph 2.6, page 16 states the following. From the foregoing it comes clear that the evidence places Gwabini at the center of the events of the 26th of October 2014, and his evidence needs to be placed before court in its entirety, close quotation. I submit that the defense had never said that the evidence of Gwabini about the events of the 26th of October 2014 should not be put in its entirety in relation to the version of Constable Skhumbuzo Sizwe Zungu. The court had indicated to the state that it should firstly, or as a matter of introduction to the alleged statement made by Gwabini, prove the statement without referring to the portion of the statement regarding to the address and the date that statement was allegedly made by Gwabini. I submit in this regard that the filing of heads of arguments by the state has not ventilated the issues but summarized the evidence of Constable Zungu and that of Gwabini. 10.2, paragraph 4.1, page 18 states the following. In the matter at hand, Gwabini was initially a state witness, but he was not called as he expressed fear of reprisal, and now that he has been called as a defense witness. He testified that accused one are brothers, open bracket, their mothers are sisters, close bracket, and he referred to accused number 4 as uncle. He knows accused number 2, who grew up in the nearby village of Kotlokolo. In Makala decision and another, the Constitutional Court confirmed the findings of the SCA that the witness was a brother of the first applicant, and that is probably the reason for him to reignite. 10.2.1, I submit that the state remarks are regrettable and should be condoned, and it cannot make such remarks as the state did not use the provisions of sections 204 and 190 of the Act for the state to arrive at this conclusion. Gwabini was not called by the state but by the defense. The court further was not privy to the contents of the alleged statement. In Kaso, Gwabini has not reignited but merely says specifically recant his alleged statement, but merely certified that when Brigadier Kininda and Sergeant Mohola interacted with him at Primrose Police Station, they informed him that accused number 1, Mozi, had already made a statement. They said it would be beneficial if something is written down, as Mozi had said something about him. He then told them to bring over what Mozi has written. Maybe he, that is accused number 1, did not know that he knew nothing. At paragraph 10.3, I continue to discuss the response. In the heads of argument, at paragraph 4.3, page 10, the state says the following. The Constitutional Court had to consider whether the statement by the witness Luzu Makala constitute hearsay evidence in terms of Hearsay Act paragraph 67. If referred to the definition of hearsay evidence in terms of section 3, subsection 4 of the Hearsay Act 45 of 1988 as evidence, whether oral or in writing, the probative value of which depends on the credibility of any person other than the person giving such evidence. Close quotation. At 10.5, as a point of departure, the question for determination in the present application is not whether Gwabini is a witness in terms of section 204 of the Act, or that the state may cross-examine him that is Gwabini, on the contents of the alleged statement. The point is that the state must first lay a foundation to prove the statement before it can cross-examine on the statement to Gwabini. I'm also of the same view, my lord, that the Makala decision is totally distinguishable from the facts of this case. But what I wish to highlight is that the state cannot then draw any similarities between the evidence in chief of Gwabini and the decision of Makala, because the decision of Makala was overturned by the Constitutional Court. In conclusion, my lord, the question for determination, therefore, is the following. That is now in relation to the suggestion that a trial within a trial may be held. Can a trial within a trial be conducted to determine the admissibility of the alleged statement made in terms of the provisions of Section 204 of the Criminal Procedure Act in circumstances where a witness was a state witness and the state failed to use the mechanism available to it? Those are the provisions of Section 204 and Section 190 of the Act to declare a witness hostile, where the witness recants from his statement. Because the problem that I'm submitting the court will be faced with, the court will be called upon to make the credibility finding that in fact that witness, which is Gwabini in the circumstances, did indeed make a statement. The answer to the question that I've asked above will then therefore be insurmountable for the state. My lord, I'm having a different view because law is not mathematics. It is not 1 + 1 = 2. But my submission in this issue is that the state had two mechanisms to use to this witness, that is Gwabini. The first one I violated, it is the provisions of Section 204 of the Criminal Procedure Act. That mechanism the state did not use. The second one is the provisions of Section 190 of the Criminal Procedure Act, where such a witness recants from his earlier statement. The state can therefore declare such a witness hostile. Can it then be said in the circumstances where the state did not use the two mechanisms, the state then be allowed to cross-examine the said witness, who was the state witness and who has become the defense witness, to cross-examine him? I find the answer to be in the negative, my lord. Those are my submissions. Thank you.
Okay.